Hi, this is Mr. Seymour. This is Chapter 13, the courts, the judicial branch. People outside the Supreme Court in April 2016 are seen urging the Senate to do their job and hold hearings on the nomination of Merrick Garland. The vacancy in 2016 was one of the longest for the court in U.S. history. The Founding Fathers disagreed on the power that should be given to the judicial branch. Federalists believed the new Supreme Court would be too weak, and Anti-Federalists believed it would be too strong. Congress set up a judiciary system, including a lower court structure, in the Judiciary Act of 1789. This also created 13 district courts and 3 circuit courts. It set the initial Supreme Court size at 6. There's little in the Constitution about the judiciary other than the establishment of the Supreme Court. Judicial review, which is an important concept and the basis for the power of the judiciary, is not even mentioned. Judicial review is the power of the courts to overturn legislation or policy on basis of constitutionality. Most details on court structure come from the Judiciary Act of 1789. That act created appellate jurisdiction for the court system, which included the ability to hear appeals from the state Supreme Courts on issues of federal law. Now, this is Article 3 in a nutshell, which is where we find judicial power. The jurisdiction of lower-level federal courts involves cases involving the United States Constitution, federal laws, and treaties. Controversies between 2 or more states, which is Congress passing a law giving Supreme Court executive decision over the cases. Controversies between citizens of different states. Controversies between a state and citizens of another state, which the 11th Amendment removed federal jurisdiction in these cases. Controversies between a state or its citizen and in any foreign state, citizen or subject. Cases affecting ambassadors, public ministers, and consuls. Cases of admiralty and maritime jurisdiction. Controversies between citizens of the same state, claiming lands under grants of different states. Now, the original jurisdiction of the Supreme Court is cases involving ambassadors, public ministers, and consuls, in cases to which a state is a party. This is John Marshall, and he was the first Chief Justice, and it was imperative in establishing the ability of the Supreme Court to hear appellate cases by way of judicial review. Chief Justice John Marshall favored the idea of judicial review and claimed this power for the court in the case of Marbury versus Madison. Now, in this case, John Adams, who was a Federalist, lost an election to Thomas Jefferson, who was an Anti-Federalist. Adams named several Federalist appointments at the 11th hour before turning over power to Jefferson. Marbury, who was one of the newly appointed Federalist judges, didn't receive his commission as Jefferson didn't deliver it. Marbury filed a lawsuit to get his job back. The Supreme Court had jurisdiction over the lawsuit according to the Judiciary Act of 1789. The dilemma was that Marshall agreed wholly with Marbury, but if he decided against Jefferson, the president might ignore the court's ruling. So the result was that it was argued that the court did not have jurisdiction to decide this case and struck down part of the Judiciary Act. They refused the power to review law, and in so doing created much more power for themselves because they got the power to review law. Judicial review, which comes through the case of Marbury versus Madison, gives the courts the right to strike down a law, or the power to strike down a law, and it made the court a co-equal branch of government. But it's been rarely used. The court has struck down about 180 national laws, which is less than 0.25% of all national laws that have been passed, and about 1,400 state laws. Why is the standard of evidence so low in a civil case in comparison to a criminal case. Currently, people can face a criminal trial and a civil trial for the same incident without triggering the Constitution's ban on double jeopardy. That's what the law says, but is the law right? What are the arguments for and against being able to be tried both in a civil and criminal court, as O.J. Simpson was? We'll talk about that a little bit later. So here's some court fundamentals. Most cases are taken care of through a process called plea bargaining, which often occurs before court verdicts are ever reached. The standard of proof in a criminal court is beyond a reasonable doubt. In a civil court, it's the preponderance of the evidence. The burden of proof is on the plaintiff. The adversarial system gives both sides of a case access to the relevant information. Precedent, or stare decisis, means let the decision stand. Precedent is previous cases that must be considered when determining how a case is going to be decided. Previously decided cases and sets of decisions serve as a guide for future cases on the same topic. Collusion is when both sides are working together and are not adversarial. Standing is the right that a person has to have his case heard by a particular court. Mootness is whether or not the case is relevant, or there's a decision that can be made in a case. And jurisdiction is the court's legislative or constitutional authority to hear a case. There's controversy over judicial elections. Some people desire the responsiveness that's associated with elections, while others are concerned about conflicts of interest and intergroup involvement. Of 147 state-level trial courts, governors appoint to 6, the legislature appoints to 5, 39 of them are decided by partisan election, 34 by nonpartisan election, and 46 of them through the Missouri Plan. Now, the Missouri Plan is where the governor nominates a candidate from a list compiled by a screening committee. Then the state Senate confirms the nomination, and then there's a periodic nonpartisan retention election to decide whether or not that the judge is doing his or her job. Presidents can influence the direction of federal courts by selecting judges who share their views. President Obama is shown with Judge Merrick Garland, who he nominated to the U.S. Supreme Court to fill the vacancy created by the death of Justice Antonin Scalia. But Merrick Garland never got confirmed. The rules in terms of who you can nominate there are no rules. There are no requirements on qualifications. You don't have to have a law degree. You don't have to have been a judge before. The president can appoint anybody the president wants to. They're nominated by the president and then confirmed by the Senate, which is an often contentious process. Most confirmations happen on the basis of ideology, not on the basis of qualifications. Presidents want to pick judges and justices who share their view on issues. This does not always work out in the way the president intended. Earl Warren, for instance, was much more liberal than President Eisenhower thought he would be. David Souter was less conservative than George H.W. Bush thought he would be. The role of the president, though, is to select the judge. And that oftentimes is going to establish the president's legacy far beyond the president's term in office. Now, Franklin Roosevelt realized this, and he tried adding 3 new positions onto the court, which was called the court packing scheme, and it failed. The Senate has become much more active in its role to advise and consent. Nominees are rarely rejected on the grounds of competence, but more often because of ideology or politics. Since the 1980s, the proportion of women on the federal bench has gone up by 5-fold, while the percentage of men has plummeted by more than half. Do you think that descriptive representation in the judicial branch is important? In other words, should there be an equal number of men and women. Since the 1980s, the length of time needed to confirm federal court nominations has increased dramatically. Why do you think this happened, and why does it matter? The Supreme Court's workload appears to be headed in two directions. The court is receiving more cases but hearing fewer of them. What are the implications of having the Supreme Court hear fewer cases? And should something be done to try to get the court to hear more cases? In 2015, roughly 7,000 cases were available for review. Out of the 7,000 cases that were available for review, 75 were actually heard by the Supreme Court, where they held arguments. Original jurisdiction for the Supreme Court deals with interstate conflicts, conflicts between two states, and so forth. A matter of right, Congress asked the Supreme Court of the United States, the SCOTUS, to review a case. That's called a matter of right. A writ of certification is when the lower court asks the SCOTUS, the Supreme Court of the United States, to clarify a point. A writ of certiorari is when the loser from one case files a petition to the Supreme Court of the United States to hear that case on appeal. This is the way that most cases get before the Supreme Court. A cert pool is when the law clerks screen all cases and recommend those that they feel should be heard. So the first thing will happen is, if you want to get your case heard by the Supreme Court, it's going to be read by a law clerk. The discuss list is when the justices add items to their agenda and the order is decided by the Chief Justice, and then they talk about it. Then you have the rule of 4. 4 justices need to vote to grant a case a writ of certiorari, which means the case will be heard. The role of the Solicitor General is the presidential appointee of the Department of Justice who asks the Supreme Court of the United States to review cases for him. Now, there's different kinds of decisions that come down from the Supreme Court. Majority opinions are court decisions that the court must be agreed upon by at least 5 justices. The majority opinion represents the legal reasoning of the court's decision. A concurring opinion is written by a justice who agrees with the outcome of the case, but not with part of the legal reasoning. Concurring opinions may be joined by other justices. A justice may sign on to the majority opinion and write a separate concurring opinion. Plurality opinions occur when a majority cannot agree on the legal reasoning in a case. The plurality opinion is the one that has the most agreement, usually 3 or 4 justices. Because of the fractured nature of these opinions, they typically are not viewed as having much clout as majority opinions. So these are 5-4 rulings, for instance. That's a plurality. Dissenting opinions, submitted by a justice who disagrees with the outcome of a case. Other justices can sign on to a dissent or can write their own. So there can be as many as 4 dissents. Justices can also sign on to part of a dissent, but not the entire opinion. And per curiam, which are Latin for by the court opinions, are unsigned opinions of the court or decision written by the entire court. But this is not the same as a unanimous decision that is signed by the entire court. Per curiam opinions are usually very short opinions on non-controversial issues, but not always. For example, in the case of Bush versus Gore, which decided the outcome of the 2000 presidential election, it was a per curiam opinion. Per curiam decisions may also have dissents. Cameras are not allowed in the Supreme Court, so artist sketches are the only images of oral arguments. Depicted here is the oral argument in the case of 2016 case concerning the affirmative action policy of the University of Texas at Austin, which is Fisher versus Texas. Now, the process of getting your case in front of the court. First is selection of the case. Then comes briefs. including what we call amicus curiae, which are friend of the court briefs, which can be filed by anybody. Then come oral arguments, which are limited to about an hour and a half each. Then come the conference where the judges get together and decide how they're going to rule on the case, and they openly debate it. And then opinion writing. The Chief Justice or Senior Justice assigns the opinion to be written. If he or she is in the majority, the Chief Justice decides who will write the majority opinion. Otherwise, the most senior justice in the majority makes this decision. Since being named Chief Justice in 2005, John Roberts has spread opinion writing duties fairly evenly among the judges. In a survey taken about the judicial branch, most respondents were unable to name any Supreme Court justices. Just so you're not in any danger of falling into that category. As of the fall of 2017, the justices were from front row from the left: U.S. Supreme Court Associate Justices Ruth Bader Ginsburg, Anthony M. Kennedy, Chief Justice John G. Roberts, Associate Justices Clarence Thomas and Stephen Breyer. Back row from left, Associate Justices Elena Kagan, Samuel Alito Jr., Sonia Sotomayor, and Neil Gorsuch, the newest justice. Senate hearings on Supreme Court nominations have been more conflictual since the 1960s. Although President Obama's nomination of Sonia Sotomayor was confirmed by a 68-31 vote in 2009, Senate Republicans challenged her to explain and defend her views on several issues. Remember that legal precedent is previous cases in this involving the subject at hand. The constitutional language, when it comes to how precedent is viewed, are strict construction and living constitution and original intent. Strict construction says that we go by the precedent. We don't shift from the precedent of previous decisions. Original intent says that we consider the original intent of the founding fathers and we try to go by the Constitution. Living Constitution says we can stray away from constitutional or precedent and make new decisions and basically blaze new trails. We see evidence of each of these political factors in judicial decision making. An attitudinalist approach shows that justices are not bound by precedent, but able to choose the specific precedent that allows them to achieve their policy goals. The strategic model helps explain the court's reluctance to consider political cases and why, for instance, in Baker versus Carr, it was so contentious. Baker versus Carr, remember, is one of those decisions that dealt with affirmative action. Also shows the court's willingness to make decisions consonant with public opinion, or else slow the process, as it did with Brown versus Board of Education, to establish legal footing should it go against public opinion. Judicial activism is not liberal or conservative. It is simply a court's willingness to defer to the elected branches of government. After Justice Antonin Scalia died in early 2016, the open seat on the Supreme Court became a major issue in the presidential election. Why? As this figure shows, when justices are replaced, the ideological shifts can be quite large, as when Clarence Thomas replaced Thurgood Marshall, or non-existence, as when Sonia Sotomayor replaced David Souter. Many people said that replacing Scalia would drastically alter the ideological makeup of the court, given the 4-4 split of the court between liberal and conservative justices. What do you think? High school students in Mays, Kansas, joined hands around a flagpole at the annual nationwide event calling Christian youth to pre-class schoolyard prayer at the start of the new school year. Enforcing the prohibition of school prayer and drawing the line between permissible and impermissible prayer have been difficult for the court. The court has been an important protector of majority rights, including in the civil rights era. This picture from 1953 shows people waiting in line at the Supreme Court to hear oral arguments in Brown versus Board of Education. But at other times, the court has supported the will of the majority. Here is O.J. Simpson's famous "If it doesn't fit, you must acquit" moment. O.J. Simpson is donning a pair of gloves during testimony in his double murder trial in Los Angeles in June 1995. The jury was not convinced of his guilt beyond a reasonable doubt and thus acquitted him in his criminal trial. However, a subsequent civil trial found that a preponderance of the evidence was against him. When they have been in the minority party in the Senate, both Democrats and Republicans have been willing to use the filibuster to block judicial nominees. And remember, the filibuster is keeping control of the floor so that a piece of legislation cannot pass or has difficulty passing. The role of the court as policymaker is limited. The court must rely on political capital and reputation in order to be able to get compliance and to implement. They have no independent source of enforcement power beyond the executive branch, which is there to execute the law. They must tread lightly to retain the support of elected branches. In terms of relationships with other branches in general, think of these relationships as strained. Congress can always attempt to pass legislation that can overturn a court's decision. Recent sentencing guideline controversies as an example of interplay between court and Congress. The court tends to exercise self-imposed restraint. The court essentially reserves the right to decide which political issues to defer on and which issues to engage on. Controversial issues will always bring accusations that the court is using ideology to wage politics by other means, meaning that it is suppressing democracy. Does the court follow public opinion or protect minority rights? Recent evidence shows that the court is constrained by fear that the public will ignore an unpopular ruling. Let's look at how things work in theory. You have two separate court systems, a state and local court system and a federal court system. You have trial courts at both levels, and then you have courts of appeals at both levels, intermediate courts of appeals. From there, you have the highest court. Texas has two highest courts. We have the Texas Supreme Court, which hears civil cases and judicial and juvenile justice cases, and we have the Texas Court of Criminal Appeals, which hears criminal cases. The United States Supreme Court received 7,033 filings in 2014-2015 term, and of those 75 cases were argued. Of the 75 cases, 66 had signed opinions. If a case is important enough, it can go from the state Supreme Court to the United States Supreme Court at the court's discretion. In practice, this is a look at same-sex marriage through the court system. Lower courts awarded the right to marry for same-sex couples. Following the Supreme Court's landmark ruling in 2013 striking down the Defense of Marriage Act, more than 24 state courts and federal district courts struck down bans on same-sex marriage. But 11 federal district court decisions were appealed by states attempting to uphold their bans. Federal Courts of Appeals rulings from the 4th, 7th, 9th, and 10th circuits represented 23 states and struck down state-level bans on same-sex marriage as unconstitutional. 6 federal district court cases from Michigan, Ohio, Kentucky, and Tennessee were appealed to the Sixth Circuit Court, which upheld the bans on same-sex marriages in those 4 states. The conflict between the circuit courts meant that same-sex marriage was legal in some states but not in others. At the end of June 2015, same-sex couples could marry in 29 states and the District of Columbia, but not in 21 states. So to resolve this, it goes to the Supreme Court. The Supreme Court resolved this conflict in a landmark 5-4 decision called Obergefell v. Hodges, holding that the fundamental right to marry is guaranteed to same-sex couples by both the Due Process Clause and the Equal Protection Clause of the 14th Amendment of the United States Constitution.